All right, let's dive right in. If you're doing any kind of business in India, you need to listen up because the way you handle personal data has completely, fundamentally changed. We're going to break down the new Digital Personal Data Protection Act, the DPDP Act, and talk about exactly what you need to do to stay on the right side of the law.
So, as of late 2025, the game is officially different. India's new Data Protection Act is here, and trust me, this is not just some minor update. It's a total overhaul that redefines all the rules for how you manage and protect people's personal information. So, how did this all happen? Well, the government didn't just flip a switch and spring this on everyone. They actually laid out a pretty specific timeline to give businesses a chance to adapt.
They set up this clear three-phase timeline, which is basically a roadmap to compliance. It all kicked off with setting up the basic governance in late 2025. A year after that, it was all about registering consent managers. And the final deadline, the big one, is for full operational compliance by May 2027.
Now, at the very heart of this new law is this key concept, a new role called the Data Fiduciary. And here's the single most important thing to understand. If your business handles any personal data in India, you are a data fiduciary. That's you.
Let's put it simply. If your business is the one deciding why you're collecting someone's data, for marketing, for payroll, whatever, and how you're going to use it, then congratulations, you are a data fiduciary. You're now the official trustee of that person's information. And this, right here, is the most critical part. The primary legal responsibility for protecting that data, and for anything that goes wrong, like a breach, it now rests squarely on your shoulders. As the fiduciary, the buck officially stops with you.
It's also really important to know this role is totally different from a data processor. Think of a processor as someone like your cloud provider or maybe a third-party payroll service. They're just following your instructions. Now, if they have a security breach, they have to tell you. But it's you, the fiduciary, who's legally on the hook to report it to the authorities.
But wait, it doesn't stop there. The law actually goes a step further, and it creates this special, higher risk category for certain types of organizations.
So this is the next big question you have to ask yourself. Do our operations put us into this higher risk category? And this isn't about how much money you make or how big your company is. It's all about the nature and the scale of the data that you're handling.
The government decides who gets labeled a significant data fiduciary, or SDF, based on some very specific risk factors. They look at things like the sheer volume of data you process, how sensitive it is, we're talking health records, financial data, and what the potential harm could be to people or even public order if there's a breach.
And believe me, if you get designated as an SDF, you've got a whole new list of serious responsibilities. For one, you're required to appoint a data protection officer who's actually based in India. You also have to conduct mandatory data protection impact assessments for any high-risk stuff you're doing. And yeah, you'll be facing regular, periodic compliance audits.
But here's the thing. Whether you're an SDF or not, it doesn't matter for this next part. There is a core set of duties that are absolutely non-negotiable for every single data fiduciary out there.
Okay, so these are the absolute basics, the ground rules. You must have strong, reasonable security measures in place. You have to be totally transparent with your users about how their data is being used, and you have to get their consent before you do anything. And finally, you need to have a system where they can file a complaint and actually get a response.
And when we talk about data breaches, the timeline is incredibly tight. You have just 72 hours from the second you realize there's been a breach to report it to the Data Protection Board and to the people who were affected. That's it.
The law also sets a very clear deadline for handling complaints from your users. If a customer or an employee files a data-related grievance, the clock starts ticking. You have a maximum of 90 days to get it resolved. So, why are we talking about all this? Why does it matter so much? Well, because the stakes have never, ever been higher. This act introduces penalties that are big enough to absolutely cripple a business.
The maximum penalty is a mind-boggling 250 crore rupees. That's roughly 30 million US dollars. And that's what you could be facing for failing to have the right security in place to prevent a data breach.
And remember that 72-hour notification window we just talked about? If you miss it, that mistake could cost you up to 200 crore rupees. That's about 24 million US dollars.
And for all the significant data fiduciaries out there, there's a whole separate penalty of up to 150 crore rupees, or $18 million, just for failing to meet your extra obligations, like appointing a DPO or doing those audits.
Okay, so what should you be doing, right now?
Let's talk practical first steps. Number 1, map your data. You need to know exactly what data you have, where it is, and where it goes. 2, update your privacy notices. They have to be crystal clear and specific. 3, review your contracts. Make sure all your vendor agreements are up to the new DPDP standards. 4, log everything. You need a process for logging data transfers and user consent. And finally, number 5, have a breach plan. You need a clear, time-bound response plan ready to go before you ever need it.
Look, the DPDP Act isn't just another regulation you can check off a list. It's a fundamental shift in how we have to think about being stewards of data. It demands immediate, focused attention from every single organization that handles the personal data of people in India. The question is, are you ready?